Thank you.
Good morning, Ms. Stevenson.
Good morning.
I see that you've been watching, but just so that you realize you have 10 minutes.
Yes, ma'am.
And the clock will say 9876, and then when you get to 1 minute more to argue, the orange light will begin flashing.
Yes,
and when the red light begins to flash is when you have to stop.
Yes, ma'am.
Okay?
Yes, ma'am.
Good morning, Ms. Stevenson.
Good morning, Janice Stevenson. This court can provide resolution to the question of the appealability or validity of non-written counterclaims. The governing case is Bishkoff versus Kern. This court can provide resolution to the question of proper transfer practices within the small claims court. That holding case is Dom versus Delta, and also the resolution of subject matter jurisdiction within a small claims court case. There is a systemic issue within the small claims court affecting its proper administration of the issues I just listed. The judge did not recognize an oral counterclaim of the defendant, which stated that the wages collected by the United States Department of Labor was not subject to damages within the claims that I had brought to the small claims court because those wages were not reported to the Attorney General. That particular claim is on page 5, line 5 through 16 of the transcript. Also, that judge did not record a motion I had submitted at the beginning of the hearing in which I asked it to consider additional amount above the $2,000 limit of the small claims court, or if he couldn't do that, to transfer it to district court. Within the definition given by the holding case for a counterclaim states that in the counterclaim situation, there is no basis expressed otherwise upon which to infer a waiver of a right to a jury trial. It says here, the term a counterclaim is a broad, there are no compulsory counterclaims in small claims procedure, but a defendant may choose to assert any counterclaim within the district or municipal court small claims jurisdiction. Rule 3C defines a counterclaim very broadly as any claim which the defendant has against the plaintiff, and therefore a small claims counterclaim need not arise out of the same incident giving rise to the complaint. An available remedy normally from the small claims procedure in Chapter 218, Section 23, provides that the trial by jury of 6 in a district court department shall proceed in accordance with the provisions of law applicable to trials by jury in a superior court department. Chapter 211A, Section 10 provides appellate jurisdiction to the appeals court over decisions of both the superior court and of the district court department in jury session. Taken together, these two provisions indicate there is an appellate remedy from small claims jury sessions under Chapter 218, Section 23. However, when I went to file my appeal, I was told they did not recognize a counterclaim because it was not written. This was told to me in the small claims department, and this was told to me in the Boston Municipal Court. And when I went to ask about my motion, they said there was no record of my motion. So I could not, on any of those provisions given to me within the law, get an appeal. So I had to invoke the superintendent's powers of this court to try to get a resolution to my problem. And part of my concern was that I could not go over to the Superior Court because I did not feel that the amounts of my damages would have met that limit, because with the damages here, it's a judge's discretion as to how much you will get. So I felt as if the assistant clerk, administrative clerk, the assistant magistrate clerk was acting as a gatekeeper, and I don't think that should have been within the jurisdiction. I don't think that's within the jurisdiction of that particular.
Stevenson, did you ever seek relief under Rule 8 of the Uniform Small Claims Procedure Rules? That is, seek relief from a judge in the Boston Municipal Court from the well, just take the non-docketing or the loss of your particular motions?
When I went to them, I sought an appeal, and they would not take the paperwork for me or proceed any further. At that point, I did ask to speak to like who was in charge, like the head judge, and I left a note, but I didn't like write a motion. I left a note on the 20th, and I never got a call back from anyone who can assist me, and that is when I came to this court. And right now, to this day, I don't know what else I could have done, because that docket would have limited what I could have brought up. And I think that was probably my problem, because it would have been an uphill battle to go before a judge and say, you know, I filed this document, and they made this counterclaim, because at that time I didn't have a transcript, so it would have been basically just my word against an assistant clerk magistrate. And my petition attempted to demonstrate my inability to obtain the prescribed appellate remedy through the small claims office to the district court. The impasse in both offices was the judge's lack of recording on the docket sheet, even my motion to transfer. And within some of the cases I have found, in Dom versus Delta Airlines, the court, it states that a judge should be mindful of not allowing a person to transfer to the district court, and that the small claims court is an exception. It's not exclusive, it's non-exclusive within the district court.
Ms. Stevenson, could I ask you as well, for all of the initial claim of the failure to pay wages in a timely manner,
yes, ma'am.
You have been paid all of your wages, correct?
Yes, ma'am.
And without going into details, what was the nature of the counterclaim, of your counterclaim?
The nature of what I consider was the counterclaim was when he told the judge that basically it wasn't going to be the total amount I collected from the U.S. Department of Labor. It was just going to be the amount presented to the Attorney General. So it went from the $5,000 to a little under $102.
Okay, thank you. You have a few more seconds if you'd like to.
Well, basically, I felt like this falls within the jurisdiction of this court, and I am asking this court to provide me with
A remedy.
a remedy.
Yeah.
Thank you.
Thank you, Ms. Stevenson. Mr. Hopp? Good morning.
Your Honors. My name is William Hoke, and I am counsel with the Massachusetts Port Authority, representing Dave Mackey, the Chief Legal Counsel, and Sandra Casey-Buford, the Director of the Diversity Department, who are the two named defendants in this case. This case arose from a situation of late payment of wages, and the counterclaims that Ms. Stevenson is discussing arise because when she went first to the Attorney General's office, as she's required to by statute, with her claim that she was not paid wages. She was paid them within a week or two, at which point the Attorney General's office, the record shows, decided to close the matter because she had been paid. So she had her first attempt to recover damages, to recover her wages with the Attorney General's office. They chose not to go forward on it. She later on receives a right to sue letter from the Attorney General's office, a right to sue letter against the Massachusetts Port Authority, and a right to sue letter arising out of the claim for 1 week's overtime that was paid to her allegedly late. When she went to the small claims court, and we were before the clerk magistrate, what I tried to do as counsel for the defendants was make our point to the clerk magistrate that this was not a case about unpaid wages. It was not a case about a settlement of another overtime claim that Ms. Stevenson had brought to the Department of Labor. It was a case arising from her complaint to the Attorney General's office for 1 week's late payment of wages that she got a right to sue letter on. So that was not a counterclaim. The defendants were not claiming that they were owed any money by Ms. Stevenson. They were not claiming that she had violated any duty to them. They were merely, and I for them, was arguing that the damages needed to be focused on essentially interest on 2 weeks late payment of $100-some-odd. So that the damage in this case were extremely small, if the small claims court even found in Ms. Stevenson's favor. After losing at the small claims court, Ms. Stevenson tries to appeal, and she files a notice of appeal claiming she was a defendant in counterclaim. And a defendant in counterclaim would have a right to an appeal, but a plaintiff doesn't. A plaintiff at the small claims court clearly has no right to an appeal, and because of that, no right to relief under Chapter 211, Section 3.
Excuse me, Mr. Hoke. In the small claims, she was the plaintiff?
She was the plaintiff of the small claims because she had filed suit alleging that she had overtime wages that were paid to her late, and that she was seeking damages from
It's under
that.
her right to sue letter that she became the plaintiff.
That's correct, Your Honor. The small claims court refused to recognize her right to appeal because she was the plaintiff. There were no counterclaims filed in writing, and in the small claims court, counterclaims need to be filed in writing. Even in the oral argument, as put forward in the transcript that Ms. Stevenson typed up, we objected to that transcript, but even if it's accepted, there are no counterclaims orally put forward. There is a discussion of what the appropriate scope of the case is. So there's at no point that she becomes a defendant in a counterclaim that she could then use to get an appeal. When this matter went to the single justice, that was clear from the record. Her relief she requested when she first went to the single justice was a trial, to be allowed an appeal and to have a trial on this matter. The single justice dismisses this matter on the records before him with a single dismissal. There's no discussion of it, but it's clear from the record before the single justice of this court that there was no counterclaims had been filed by the defendants in this case, and that the law was very clear that there is no relief under 211.3 for a plaintiff arising.
Okay, I want to
out of
make sure
small
that
claims.
I'm absolutely clear. The claim here is that your clients made the counterclaim.
Ms. Stevenson's claim is that my clients, the defendants Mackey and Buford, made an oral counterclaim at
Okay.
the small claims hearing, which put her in the
That's
position
the
of
only
defendant.
claimed counterclaim at issue here.
That is my understanding. That is the
Okay.
only claim counterclaim. Ms. Stevenson may also view, we also had an argument with the small claims court that Mackey and Buford are not even proper defendants under Chapter 148. As public officials, they can only be held responsible for wage payments that fall directly under them. Mackey, as chief legal counsel, had no supervisory responsibility for Ms. Stevenson.
Buford is one step removed in terms of the supervisory authority.
That's just the legal dispute.
Correct, but I believe Ms. Stevenson may have also argued that was a counterclaim.
Did Ms. Stevenson claim, I thought that she claimed that she had received a written counterclaim which had never been docketed.
No, I believe Ms. Stevens' argument in terms of written documents is that she filed on the day of the hearing. We go in and sit before the clerk magistrate. He does his opening talk, and he says, are there any documents I should review as part of this case? I think asking for evidentiary documents. Ms. Stevenson at that point gives a motion to him, which is in the record, asking
transfer the
for
case.
multiple damages
Oh, okay.
or transfer of the case. Reading the motion, it essentially says I'm entitled to, I think, 5 times the damages that I believe I'm owed. It gets up to a very high number. We argue that's completely incorrect, but that, small claims court, these are the damages I seek. If you choose not to rule on this case, I'd like to transfer to the regular docket. That, because all I can speculate is because it's given to the clerk magistrate when the clerk magistrate is seeking evidence in the matter, as opposed to being filed with the clerk's office, it doesn't make it onto the docket.
But you got a copy that day.
I was given a copy of it that day, yeah. I honestly did not focus heavily on that document because we were preparing to make our argument, and I was sort of thinking through the facts of my case. Even if that's a valid request for a transfer, it's written in a way that allows for an alternative. Small claims court, rule on my case, or if you choose not to, transfer me somewhere else. The small claims court clearly chose to rule on the case, recognizing that there were legal difficulties in her
Did
claims.
the small claims hearing officer consider the additional claim for damages, totaling what Ms. Stevenson has said might be $5,000?
He heard Ms. Stevenson argue that she was entitled to them.
Yes.
The extra $5,000, Ms. Stevenson, after being fired from Massport, goes to the Department of Labor with a claim for unpaid overtime. She essentially argues, Department of Labor, I was working overtime every single week of the 6 months I was at Massport, and they only paid me for some of it. The Department of Labor interviewed her, put together an argument of why she was entitled to overtime, and contacted Massport saying they were going to do an investigation. What say you, Massport? At that point, we decided we're going to resolve this case with the Department of Labor. We were not interested in a full overtime investigation of what was going on. The $5,000 amount that the Department of Labor alleged she was owed was a small enough figure that we said we're going to settle these claims. We do not agree with them, but we will settle them, pay the $5,000, and be done with the Department of Labor.
And you did that?
And we did that, and we made payment on that.
So that when you were referring to a separate proceeding, that's the one you're
That's
talking
the
about?
separate proceeding.
Okay.
Ms. Stevenson took that and said, look, they paid me $5,000 through the Department of Labor for overtime. I want you to multiply that times ultimately 5, and I'm owed $25,000 from these 2 individual defendants.
Okay.
Again, we argued to the clerk magistrate that was not the appropriate damages in this case because we were still arising from the right to sue letter from the Attorney General's office. Ultimately, in this case, Ms. Stevenson, in coming before this court, has not argued that the single justice created any error of law or abused his discretion in any way. There are also cases, the Merides case, which I cite in my brief, where this court has been very clear that when appealing from a single justice, even a pro se appellant is required to argue why the single justice committed an error of law. You cannot just come forward at this stage and re-argue the lower court. In the Merides case, I believe it was a probate court action, and the court had very clear language that, pro se, you cannot just come forward and argue to us why. In that case, the probate court made a mistake here. You need to tell us why the single justice made a mistake. Ms. Stevenson has not done that in this case, and that alone would warrant dismissal. Taking one step removed from that, the single justice had good grounds for dismissing this case. There's no right of appeal from the small claims court, and these 2 defendants, even if there was a claim against the Massachusetts Port Authority, these 2 individual defendants are not the right defendants, and that was recognized in effect by the clerk magistrate in dismissing this case. If you have no further questions, I'd be happy to answer questions. If you have no further questions, I'd rest on my brief at this point.
Thank you, Mr. Hook.
Thank you.